Let us now understand the doctrine of caveat emptor under the Sale of Goods Act, 1930. The term caveat emptor is a Latin expression which means, "Let the buyer beware." Traditionally, this doctrine placed the responsibility on the buyer to examine the goods carefully before purchasing them. As observed by Lord Wright, the old rule of caveat emptor has gradually been replaced by caveat venditor, meaning let the seller beware. Due to the changing conditions of modern commerce and trade, this doctrine primarily finds its place in the law relating to the sale and purchase of goods. Under the Sale of Goods Act, 1930, the principle of caveat emptor is reflected in sections 14 to 17, which deal with conditions and warranties in a contract of sale. These provisions are derived from Section 14 of the English Sale of Goods Act, 1893. Thus, while the buyer must exercise caution, modern law also imposes certain responsibilities on the seller to ensure fairness in transactions. Let us now understand the meaning and object of the doctrine of caveat emptor. The doctrine of caveat emptor, meaning let the buyer beware, is based on a fundamental principle. It states that once the buyer has examined the goods, is satisfied with their suitability, and completes the purchase, he cannot later reject the goods on the ground that they are not suitable. In simple terms, the responsibility lies on the buyer to be cautious while purchasing. Now, coming to the object of this doctrine. The primary objective is to ensure that the buyer purchases goods at his own risk, after using his own skill, judgment, and inspection regarding the quality and suitability of the product. Let us now examine the statutory provision relating to the doctrine of caveat emptor. Section 16 of the Sale of Goods Act, 1930 incorporates this principle. It states that, subject to the provisions of this Act or any other law in force, there is no implied condition or warranty as to the quality or fitness for any particular purpose of goods supplied. In simple terms, the law assumes that the buyer must satisfy himself about the quality and suitability of the goods before making a purchase. Let us now understand the scope of the doctrine of caveat emptor with the help of an important case, Ward v. Hobbes, decided in 1878. In this case, the House of Lords laid down a significant principle. It was held that the seller is not expected to use any trick, artifice, or disguise to conceal defects in the goods, because doing so would amount to fraud. However, at the same time, the court clarified that the doctrine of caveat emptor does not impose a duty on the seller to disclose every defect in the goods. In other words, the seller is not bound to voluntarily reveal all defects, unless there is fraud or active concealment. On the other hand, the doctrine places an obligation on the buyer to exercise due care, skill, and judgment while purchasing the goods. Let us now understand another important case explaining the scope of caveat emptor, Wallace v. Russell, decided in 1902. In this case, the Court of Appeal clearly explained the true meaning of the doctrine. The court stated that caveat emptor does not mean that the buyer must take a chance. Rather, it means that the buyer must take care. This doctrine applies in situations where the buyer purchases specific goods, such as a horse or a painting, where he has the opportunity to inspect and use his own judgment. It also applies where the buyer voluntarily chooses the goods himself, without relying on the seller's advice. Further, it applies in cases where, by usage or agreement, it is understood that the buyer will not rely on the skill or judgment of the seller. Let us now understand the important exceptions to the doctrine of caveat emptor under the Sale of Goods Act, 1930. Although the rule says, let the buyer beware, the law provides several exceptions to protect the buyer. First, there is an implied condition as to title under Section 14. The seller must have the right to sell the goods. Second, the goods must correspond with the description given as provided under Sections 15 and 16, 2. Third, there is an implied condition as to fitness for general purpose under Section 16, 1. Fourth, where the buyer discloses his specific purpose and relies on the seller's skill or judgment, the seller must provide suitable goods. Fifth, in case of sale under a trade name, this protection may not apply, as per the proviso to Section 16, 1. Sixth, the goods must be of merchantable quality under Section 16(2), meaning they should be fit for sale in the market. Seventh, where the buyer has no opportunity to examine the goods, the doctrine does not apply strictly. Eighth, conditions may also be implied by trade usage or custom under Section 16(3). Ninth, express terms of the contract under Section 16(4) can override the general rule. And finally, in case of sale by sample under Section 17, the goods must correspond with the sample shown. Thus, these exceptions ensure that the buyer is protected against unfair practices, balancing the principle of caveat emptor. Let us now understand the first exception to the doctrine of caveat emptor, implied undertaking as to title under Section 14. In every contract of sale, unless a different intention appears, the law provides certain implied conditions and warranties. First, there is an implied condition that the seller has the right to sell the goods. In case of an agreement to sell, he must have this right at the time when ownership is to pass. Second, there is an implied warranty of quiet possession. This means the buyer shall enjoy the goods without any disturbance. Third, there is an implied warranty that the goods are free from any charge or encumbrance in favor of any third party, unless such charge is already known or disclosed to the buyer. In simple terms, the buyer is not required to investigate the seller's title. The law assumes that the seller has a valid right to sell, can transfer possession, and that the goods are free from hidden claims. The second exception to the doctrine of caveat emptor, under Section 15 and Section 16, subsection 2, where there is a contract for the sale of goods by description, there is an implied condition that the goods must correspond exactly with that description. Further, if the sale is made by sample as well as by description, it is not enough that the goods match the sample alone. They must also match the description given. This means that it is the responsibility of the seller to ensure that the goods supplied are exactly as described. If the goods do not conform to the description, the buyer has the right to reject them, even if he did not examine the goods at the time of purchase. Let us now understand the third exception to the doctrine of caveat emptor, fitness for general purpose under Section 16, subsection 1. This provision lays down that the seller is under an obligation to supply goods that are reasonably fit for the general purpose for which such goods are ordinarily used. In simple terms, when goods are sold, they must be capable of serving their basic, ordinary use. For example, if a person purchases a cycle for general use, it is the duty of the seller to ensure that the cycle is fit for normal riding. However, if the buyer intends to use the goods for a specific or special purpose, then it becomes the responsibility of the buyer to check and satisfy himself about the suitability of the goods. For instance, if a cycle is purchased for racing, that is a special purpose, and the buyer must exercise caution. Thus, in cases of general use, the doctrine of caveat emptor does not apply strictly, and the law places responsibility on the seller to provide goods fit for ordinary purposes. The fourth exception to the doctrine of caveat emptor, where the buyer expressly communicates his specific purpose to the seller and relies on the skill and judgment of the seller, there arises an implied condition that the goods shall be reasonably fit for that purpose. In such cases, the responsibility shifts from the buyer to the seller. For this rule to apply, certain conditions must be satisfied. First, the goods must be reasonably fit for the purpose for which they are required. Second, the buyer must clearly make the seller aware of his particular purpose. Third, the buyer must rely on the seller's skill or judgment while making the purchase. And fourth, the goods must be of a kind that the seller ordinarily deals in the course of his business. If all these conditions are fulfilled, and the goods fail to serve the stated purpose, the buyer has the right to reject the goods. Thus, this exception ensures protection where the buyer places trust in the seller's expertise. Let us now understand an important case illustrating the exception to caveat emptor. In the case of Sheetal Kumar Saini versus Satvir Singh, the petitioner purchased a compressor with a 1-year warranty. However, a defect appeared within just 3 months of purchase. The petitioner requested a replacement, and although the seller replaced the compressor, he failed to provide any further warranty on the replaced product. The matter was brought before the State Commission. The Commission held that the buyer was entitled to relief, stating that there is an implied warranty under Section 16 of the Sale of Goods Act 1930, that the goods must be reasonably fit for the purpose for which they are sold. Thus, the replacement without warranty was not justified, and the buyer's claim was upheld. This case clearly shows that where goods fail to meet expected standards, the law protects the buyer despite the doctrine of caveat emptor. The fifth exception to the doctrine of caveat emptor, sale under trade name. In certain cases, the buyer purchases goods not by relying on the skill or judgment of the seller, but by relying on the brand, patent, or trade name of the product. In such situations, it would be unfair to hold the seller responsible for the suitability of the goods. Therefore, the proviso to Section 16, subsection 1 clearly states that, in the case of sale of a specified article under its patent or trade name, there is no implied condition as to fitness for any particular purpose. This means that when the buyer chooses a product based on its brand name, he cannot later claim that the goods were not suitable for his specific purpose. When in cases of sale under a trade name, though there is no implied condition as to fitness for a particular purpose, the goods must still be capable of fulfilling the general purpose for which that brand is known. In other words, the product must perform the basic function associated with its brand reputation. For example, if a well-known brand is famous for durability or performance, the goods must meet that general standard expected from the brand. Thus, while the buyer cannot rely on the seller's judgment for a specific purpose, he is still entitled to expect that the product will meet the ordinary expectations of that brand. The sixth exception to the doctrine of caveat emptor, merchantable quality under Section 16, subsection 2. This provision states that where goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. Merchantable quality means that the goods must be fit for sale in the market and suitable for the ordinary purposes for which such goods are used. It is important to note that this rule applies whether the seller is the manufacturer or not, as long as he is dealing in such goods in the course of his business. Thus, the seller has a duty to supply goods that are sellable, usable, and free from defects that would make them unfit for normal use. If the goods fail to meet this standard, the buyer has the right to reject them. Therefore, this provision protects the buyer by ensuring a minimum standard of quality in commercial transactions. Let us now understand the meaning of merchantable quality in detail. Merchantable quality means that if goods are purchased for resale, they must be capable of being sold in the market under the same name or description. This concept mainly depends on two important factors. First, marketability. Merchantability does not simply mean that the goods can be sold in the market. It means that the goods should be sellable at their full value, even if goods appear to be fine. They are not considered merchantable if they contain hidden defects that make them unfit for their proper use, and such defects are not visible upon ordinary examination. Second, reasonable fitness for general purpose. If goods are purchased for personal use, they must be reasonably fit for the ordinary purpose for which such goods are generally used. For example, a person purchases a hot water bottle meant for applying heat to the body. If the bottle bursts and causes injury, it clearly shows that the goods were not of merchantable quality, and the seller will be held liable. Thus, merchantable quality ensures that goods are both marketable and fit for ordinary use, providing essential protection to the buyer. The seventh exception to the doctrine of caveat emptor. According to the proviso to Section 16, subsection 2, if the buyer has examined the goods, there is no implied condition regarding defects which such examination ought to have revealed. In other words, if defects were visible upon reasonable inspection, the buyer cannot later complain about them. However, this rule applies only when the seller has given the buyer a full and fair opportunity to examine the goods. Whether the buyer actually uses that opportunity or not is immaterial. but where it is not possible for the buyer to examine the goods, the doctrine of caveat emptor does not apply. In such cases, the law protects the buyer, and the seller remains responsible for any defects. Thus, the rule balances responsibility between the buyer's duty to inspect and the seller's duty to ensure quality. The eighth exception to the doctrine of caveat emptor, conditions implied by trade usage. Section 16, subsection 3 gives statutory recognition to customs and practices followed in a particular trade. It provides that an implied condition or warranty as to quality or fitness may arise based on the usage of trade. In simple terms, established business practices can become a part of the contract, even if they are not expressly mentioned. This principle was explained in the case of Peter Darlington Partners Limited versus Gosho Company Limited. In this case, there was a contract for the sale of canary seeds. According to the trade custom, if the seeds contained impurities, the buyer was entitled to a rebate in price, but not to reject the goods. The court upheld this trade usage as part of the contract. However, it is important to note that only reasonable customs are recognized. An unreasonable or unfair trade usage will not bind the parties. Thus, trade practices play an important role in determining rights and liabilities in a contract of sale. The ninth exception to the doctrine of caveat emptor, express terms under Section 16, subsection 4. The law allows the parties to a contract to include express conditions or warranties according to their mutual agreement. However, an important rule must be noted. An express condition or warranty does not override an implied condition or warranty, unless the express terms are clearly inconsistent with the implied provisions of the Act. In other words, implied protections given by law continue to apply, unless they are specifically excluded by the contract. For example, in a case where sleepers were supplied to a railway company, and the contract required approval by the company's experts, it was held that such a condition did not exclude the implied condition of merchantable quality. Thus, even when parties agree upon specific terms, the law ensures that basic protections to the buyer are not easily taken away. The 10th and final exception to the doctrine of caveat emptor, sale by sample under Section 17. A sale by sample occurs when there is an express or implied term in the contract that the goods shall correspond with the sample shown to the buyer. In such cases, the bulk of the goods must match the sample in quality. It is the duty of the seller to ensure that the goods delivered are exactly in accordance with the sample provided. If the goods do not correspond with the sample, the buyer has the right to reject them. Thus, in a sale by sample, the law protects the buyer by ensuring consistency between the sample and the actual goods supplied.